Good afternoon. I see some familiar faces. That's good. So I'm Christine Hawes, Vice President with the Trust and Investment Management team at Charlotte State Bank and Trust, and I welcome you. This afternoon we're going to talk about DNR, the Do Not Resuscitate versus Living Will. Because I get this a lot when I do my presentations, and they say, well, I have a DNR, so I don't need a living will. And I'm like, well, yeah, they're a little bit different. So we'll go into the details of those. So what is resuscitation? And of course, I'm not a paramedic or a firefighter. We do have a first responder in the room, but that's about as close as we are. So CPR, right, is the treatment you receive when your blood flow or breathing stops. So very important to define this. Simple effort, such as mouth-to-mouth breathing, pressing on the chest, right? Electric shock, the defibrillators, right, that we see around the AED machines. Breathing tubes to open up an airway. And of course, medications that the paramedics can administer. So that's what we're talking about with resuscitation. So making that decision is very important that you have that discussion with your medical provider. So if you are near the end of life, you have an end-stage condition, terminal condition, then you know you're not going to get well, and you do have this problem pop up, then you can choose whether you want CPR or these life-saving measures brought on. And some people have told me that it's a very traumatic thing. And especially if there's a loved one in the room, to see that happen, it's very traumatic. So sometimes they opt to not do that to someone. CPR will be administered unless there's a DNR ordered. So if you're in a nursing home or in a hospital and you have the DNR card there and you code, you're good. They're not going to try to revive you. But if you don't have that, they're going to take those life-saving measures. So it's really important to document that. Well, that's not good because that's not honoring your wish, is it? Right? So, and it does say, and this was taken from the law, it may be an easy decision or a very difficult decision, right? You've got to make those decisions for yourself. Decide while you're still able to. That's really important. Do it while you still have the cognitive ability to make any estate planning decision, especially a DNR decision. Learning more about your medical condition and what to expect in the future helps kind of frame that. Discuss with your physician the pros and cons of CPR. Because sometimes you may be left in a worse position than you were, and maybe you don't want to live with that quality of life either. A DNR order may be part of a hospice care plan, I would imagine, right, when you're having those end-of-life discussions, and hospice does a wonderful job. The focus of this care is not to prolong, right, but to treat symptoms of pain and shortness of breath and to maintain comfort. So if you have a DNR order, you can always have a right to change your mind. As long as you still have your wits about you, you can undo that DNR. So, the Do Not Resuscitate Order. And it's usually on a very brightly colored piece of paper so that it stands out. So, a Do Not Resuscitate Order, that DNR, is written by the doctor, not by the lawyer. A lot of people think they can go to the lawyer and they'll do the living will and the DNR separate. It instructs healthcare providers not to do the CPR process. If you stop breathing, your heart stops pumping. The DNR order, it's really important that the emergency room people know about this too, right? Like let's say you're brought in and you have a copy of it, helpful. It's a specific to CPR, so not other things that they can do. So they may give you other medications, that's up to them. The doctor writes the order only after talking with you about it, or your proxy or family member. So that's interesting too. So share the DNR order with your family, all physicians, hospital, and rehab. And I add on to that, share your living will and healthcare surrogate forms with your family that are named to honor your wishes, your physicians, your specialists. Very important, everybody has a copy. Because if your healthcare and living will documents and DNR are locked up in your safe deposit box at the bank, it's not doing anybody any good, right? You've got to have it with you. Even when we travel, I take our power of attorney and healthcare documents with us. Because if anybody's ever been on I-4, you need a rosary bead and your healthcare documents and your power of attorney. It is a dangerous road. So that's important to keep those with you. It really is. And share them. Share those information. Because that way your wishes are shared with the people who are going to be making those decisions. Yes? Great question. Photocopies are good. Even electronic copies are good. which is nice to know. So yes, you can make photocopies. And that, think about it. Your kid is in Michigan and you're in Florida. They get a call in the middle of the night from Fawcett Hospital. Okay, what do? Well, I'm the daughter. Okay, are you the healthcare surrogate? Yes. Do you have a copy you can scan to us so we know we have permission to speak with you openly about your mother's condition? No. But if you send it to them, they can scan their driver's license and the documents to the hospital. Boom. The communication lines are now open. And we've had times where one of our clients in the trust department has fallen ill, severe stroke or something, and we've had to deliver the living will and healthcare surrogate documents to the hospital to make sure that they weren't artificially prolonged. Yes? Right. Now, because the documents are longer and really can't be miniaturized, that's a good question. And sometimes I see those still floating around from the freebie, I call adult trick-or-treat health fairs. Yeah, exactly. And so it's nice to have, these are full-length documents, and usually the living will and healthcare surrogate go together in a combination type document. And it's really nice that way so you don't have to fumble around with different documents. So that kind of concludes that piece a little bit. If you are near the end of your life or of an illness that may not improve, you can choose whether you want this CPR to be done. CPR will be administered unless your DNR order created by your physician says don't do it. So that's important. Unable to make the decision due to injury or illness, you may not be able to state your wishes about CPR. In this case, if your doctor has already written a DNR order at your request, your family cannot override it. You know what's interesting? When you die, you have no control over your body, whether it's cremation or whole body. But during this time of life, your family can not override your wish for a DNR, which is interesting. So that's another reason to get your funeral plans done. You may have named someone to speak for you, such as a healthcare agent. Good. If so, this person or legal guardian can agree to DNR order for you. So they can say, I've had this conversation, Jeff could say, I've had this conversation with Christine. She doesn't want to live artificially. She doesn't want to be brought back to life with CPR and any kind of things of that nature. So please put the DNR on for her. It's a pretty important, I'm getting goosebumps just thinking about it. Imagine making that decision for someone else, right? If you have not named someone to speak for you, a family member or friend can agree to a DNR order for you, but only when you are not able to make your own medical decisions. So, of course, they would never turn to anybody but you unless you're unable to make those decisions. That's why it's good now while you're, with the program, doing a great job, sharp as you can be, you make the decisions so that it's locked in. So what is a living will? A little different. Because remember, DNR is a sudden drop in your health, right? Heart stops beating, you're not breathing. The living will is a little slower. Terminal condition diagnosed, end-stage condition, renal failure, persistent vegetative state like Terry Schiavo. We all remember that case, don't we? Yeah, that was a long case. So these are conditions that are, these are physicians examining you separately, making sure that this is an agreement, that you're in one of these three conditions, and then you state that you do or do not want food or water. And when I say nutrition or hydration, I mean a peg tube in your stomach or an IV in your hand for hydration or nutrition. Now, when you sign the living will, we were talking about those little cards you used to carry in your wallet that really they're not as good as you think they are. But they must be signed in the presence of two subscribing witnesses, one of whom cannot be a spouse or blood relative. So think of how many times you pick up a freebie card somewhere and you go home and family signs it. Well, that's not good. So if the principal is physically unable to sign the living will, one of the witnesses may subscribe to and put their signature on it. But I'd rather have you do it yourself when you're of sound mind and body, right? So what happens without a living will? What if you haven't declared that? What if you didn't get that chance to do that? Well, in the absence of this living will, then they're going to look at your healthcare surrogate, and they're going to hope that they can make that decision. If you didn't do a healthcare surrogate, which think about it, designation of healthcare surrogate and living will, they're done at the same time. So if you have one, you probably have the other. But if for some reason they were scattered and done separately, then they're going to look to your designated healthcare surrogate. And then if not, they're going to find a family member or friend, and then they go down a pretty big pecking order to get to the right person. So before exercising the incompetent patient's right to forego the treatment, the surrogate must satisfy that the patient does not have a reasonable medical probability of recovering. That's the standard that the doctors must have when they examine you. And when they come in to examine the patient, let's say I'm a doctor and Jeff's a doctor, I come in to examine the gentleman first without the other doctor in the room. Then he comes in to examine so that we're not influencing each other on those three positions, which is important. The patient has an end-stage condition, persistent vegetative state, or the condition is terminal. So that's the bottom line. And then, interestingly enough, when you do your documents, you can put yes or no to food or water on each of those if you want. Like you may say, well, if I'm in this condition, I want hydration, but if I'm in that condition, I don't want anything. So, and mine say that I want hydration no matter what. Not nutrition, but I don't want to be dry. You see, I always have my water with me. I'm going to die nice and plump, nice and moist, no dry. So that's important. What happens without a living will? We talked about. Who makes a determination? Determination of patient condition. We talked about those two physicians examining you independently. Very important. So, and they would have to document this and put it inside your record. So your healthcare surrogate could reference that in your patient file. And they can look and say, okay, Dr. X examined Christine and Dr. Y did, what were their determinations? And they have to put that in the medical record, signed by each of those physicians. So that sums it up. Any questions, concerns? You have any other estate planning questions? Yeah. Some people have them on a thumb drive or a cloud. You know, they put it on the cloud. But the question is, if you aren't with the program and you can't open your phone, there's a passcode or there's, you know, it gets a little tricky. So I'm old school paper, put it in an envelope, give a copy during life to hospital specialists, you know, whoever, your neighbors, whoever you think is closest to you that might be the one calling 911 or who's going to be called in case. And some people have on their phone ICE in case of emergency. So another time that person, whoever that ICE person is, should also have a copy of your healthcare directives. It is a good thing to do because that way there it takes the stress out. Because imagine that phone call in the middle of the night. Do you really want to fumble around for paperwork on top of it? Isn't it nice just to have that ready? It's a good thing. Keeps peace. Anybody have any questions about wills, power of attorney, healthcare while I'm here? How many have their estate plan done? Pretty good. That's good. Usually it's only 4 out of 10 people. But I bet after this virus, it'll be 5 out of 10. Excellent. Excellent. So the HIPAA Privacy Act was in 2005. And if any of us remember going to the doctor around 2005, 2006, you had to fill out all these extra papers. It drove you crazy. In 1999, after the Terry Schiavo incident, is when they changed our living will. So if you have documents that predate those two, I would certainly go and get them redone. And they're not expensive. I mean, really not expensive, but good to have on hand and up to date so that you do have that HIPAA privacy waiver. Otherwise, again, family members there, but they can't talk to the doctor openly or the nurses about it. And you know that if you have a kid in Illinois and they call down to the hospital, the nurse is like, I can't tell you that. But if they have that HIPAA privacy waiver, they can talk with them. I mean, and yeah. It's inside the living will and healthcare surrogate. So when the attorney creates those documents, it will bring it up to the 2005 standard, which is open communication. They can go pull your records. And sometimes that's even important, just paying a bill for somebody. If there's a medical diagnosis on something, you know, they're not allowed to look at it or see it. So when you have that HIPAA privacy waiver in there, it's great. And I'll tell you another little secret. When we do estate planning for parents who have kids or grandkids that might have an alcohol or drug problem, we'll put the HIPAA privacy waiver language in the trust document that says that that kid or person, beneficiary, has to sign a HIPAA privacy waiver so that we can actually get clearance to be able to get the drug test results. Because if we suspect that there's some funny business going on, because you don't want to give somebody who has a drug problem $50,000. That ends in a body bag. So we're very cautious about that. But it is important when you're paying bills for someone that you might end up seeing a diagnosis or moving records around from one specialist to another. You know, you have to bring your records. And So if you're a healthcare surrogate, it's important. Yes. If you have a living will before 1999, it should be redone. Healthcare HIPAA privacy waiver for your healthcare surrogate would be 2005. But usually those documents are combination ones. So I would say if anything's before 1999, it should be replaced. And really, if it's before 2005, probably a good idea to freshen it. Because sometimes attorneys will run around with documents that are a little bit out of date. We've had that happen when laws change, or some people try to do their own, with the stuff on the computer, and that's just a disaster waiting to happen. So just be real cautious with that. We're not big fans. But very good questions. Good audience. And yes? That's true. It comes from the law. You're right. Yes, the law, pretty similar. Yeah, they have software that they utilize, but the software companies go to our law. So there's the Florida Trust Code and the Florida Probate Code, and so those are at the state level, and every state's different. So if you move from state to state, it's a good idea to have those documents revisited. So that will happen. So you're right that the software will look pretty much the same from attorney to attorney. Yes, sir. That's right. It's not a bad idea to have two sets. I know it sounds crazy, but if you live 6 months in New York State, you might want to have a healthcare documents for that state and then have them in Florida as well. The reason being is if I get taken to the emergency room in Florida, isn't it nice if the staff is used to seeing my living will and healthcare surrogate forms as Florida, referring to Florida statute? Not that they would not honor the one from New York, but it might not be as comfortable of a situation. So it's not, as long as they don't conflict. Like you wouldn't want to say, yes, I want food and water here, but no, I don't in Florida. I mean, they have to be consistent. But that's the only documents where it's okay to have them in both states, and you should keep them with you when you are going from state to state. Because it is important, again, you might need to access them when you're out of town, whether it be for a couple of weeks or a couple of months, right? So good questions. Yeah, the Florida Probate Code and the Trust Code, if you ever want to sleep or you're having trouble sleeping, go on and Google that. You'll be out like a light. So I think I'm standing between you and happy hour. So, so it's good to talk with anybody. If you have a question or concern, call me, email me. I'm always available. I do free consults all the time at the bank. That's my job. Thank you.